Hello, good evening all. Welcome to another video with PRATHAM Test Prep. This is your host Sushila Chaudhary, and today we'll be talking about Law Commission on Uniform Civil Code. So, the 22nd Law Commission of India, which is chaired by former Karnataka High Court Chief Justice Rituraj Avasthi, was sought the views of religious organizations and the public on the issue of Uniform Civil Code or UCC. Now, the commission consists of Justice K.T. Shankaran, a retired High Court judge, Professor Anand Paliwal, Professor D.P. Verma, Professor Raka Arya, and M. Karunanidhi. The commission has issued a notice inviting interesting individuals and organizations to present their views within a period of 30 days. So, the interested individuals and organizations can present their views within 30 days from the date of the notice, through the provided online submission button or via email to the Law Commission of India. The stakeholders are also allowed to submit consultation, discussions on working papers on any issues related to the Uniform Civil Code to the Member Secretary of Law Commission of India in New Delhi. Now, the Law Commission may conduct personal hearings or discussions with individuals and organizations if necessary. What is the reason why why is this 22nd Law Commission seeking fresh views and suggestions? So the reason is the move exactly comes in response to petitions before the Supreme Court calling for uniformity in laws governing divorce, succession, inheritance, adoption and guardianship. The central government had earlier informed the Supreme Court in October 2022 that the commission obligated the state to have a UCC, emphasizing the need for unity and uniformity in laws across the religious communities. The Congress party has criticized the Law Commission's decision, citing that the 21st Law Commission stance that a UCC is neither necessary or desirable at this stage in India. They assert that the interests of the nation should not be conflated by political ambitions. This move is being criticized as people think that the current government in power is trying to use this UCC in their advantage for the coming up elections. The other political parties including JDU, RJD, Trinamool Congress have also opposed the government's move. However, parties like AAP, that is Aam Aadmi Party, which previously expressed support for a UCC, have remained silent this time. Now, let's get into what exactly is UCC. So, UCC seeks to provide one law for the entire country applicable to all religious communities in their personal matters such as marriage, divorce, inheritance, adoption, etc. Now, prior to independence, only criminal laws were codified and made universally applicable, while the personal laws were still governed by several community-specific ordinances. As of now, Indian personal laws are fairly complex, with each religion adhering to its own specific law, and additionally in the religion also, when there are different sects, they have their own personal laws, and there are separate laws that govern Hindus, including Sikhs, Jain, Buddhists, and then there are personal laws of Muslims, Christians and other followers of other religion. Now let's take a look at the origin and the development of UCC. Before we do that, there is one thing that we need to note here is currently in India, personal laws differ across religions, like we have discussed, like including Hindus have their own specific laws, similarly for Muslims and Christians. But there is only one exception, one state in India which follows UCC, and that is Goa. In Goa, all religions follow a common law regarding marriages and divorces and adoption. Now, let's come to the origin and development of UCC. So, the idea of UCC in India can be traced back to the colonial times, when the British government submitted a report in 1835 emphasizing the need for uniformity in the codification of Indian law, excluding the personal laws of Hindus and Muslims. Then later on in 1941, the colonial government formed B.N. Rao Committee to codify Hindu law. The Hindu Law Committee recommended a codified Hindu law based on scriptures that would provide equal rights to women. The committee's recommendation led to adoption of Hindu Succession Act, Hindu Marriage Act. Mainly the adoption of Hindu Succession Act in 1956. The act amended the act amended and codified related to interstate succession among Hindus, Buddhists, Jains and Sikhs. The Hindu Succession Act was a part of series that reformed Hindu personal laws, including Hindu Marriage Act, Hindu Adoption and Maintenance Act, all enacted in 1955 and 1956. The Hindu Succession Act granted women greater property rights, ownership, allowing them to inherit their father's estates. Initially, the act provided general rules of succession for males to die intestate, giving preferences to their heirs in class 1 over the heirs in other classes. In 2005, an amendment to the act further enhanced the right of female descendants by elevating them to class 1 heirs. Daughters were granted an equal share as sons in inheritance. So, and in this discussion of origin and development, we can see that our first Law Minister of India, Dr. B.R. Ambedkar, actually believed that uniform civil code was desirable, but he held that its implementation should be postponed until a more suitable time. Then later on in 2018, the 21st Law Commission of India releases a consultation paper on reform of family law and opines that a UCC is neither necessary nor desirable at this stage. Let's take a deeper look into the 21st Law Commission. So the 21st Law Commission initially examined the subject of uniform civil code and sought views from the stakeholders through appeals and questionnaires in 2016 and subsequent public notices in 2018. So you can see right now how 22nd Law Commission is doing, that they are asking, they're seeking views from the stakeholders. The same thing happened back in 2018. And as a result, it issued a consultation paper on reforms of family law in August 2018 based on the responses received by it. In its 2018 consultation paper on family law reforms, it argued for reforming family laws of every religion through amendments and codification to ensure gender justice rather than pursuing a UCC or a uniform civil code. The 21st Law Commission also emphasized the importance of preserving cultural diversity and not compromising the individual's freedom of faith while striving for gender equality. Now, that we have talked about cultural diversity, a person's gender equality, let's see what is the Constitution's view on religion as well as the Uniform Civil Code. Now, coming to Constitution, the first three articles, that are Article 25, 26 and 29, they protect a person's right to religion. So, Article 25 lays down an individual's right to religion. Article 26b upholds the right of each religious denomination or section thereof to manage their own affairs in the matter of religion. And Article 29 defines the right to conserve distinctive religion, and individuals' freedom of religion under Article 25 is subject to public order, health and morality obviously, and other provisions relating to fundamental right, but a group's freedom under Article 26 has not been subjected to other fundamental right. Now coming on to Article 44, which actually calls for a UCC. So Article 44 is of Part 4 of our Constitution, and it is among the directive principles of state policy. So the Article 24, which calls for a UCC, says that it places a greater duty on the state compared to other directive principles to have a uniform civil code. But like we know, directive principles are not enforceable in court. So this is the view about religion as well as UCC in our Constitution. Now let's come on to what is the need for UCC. So the need for UCC is it basically ensures equality amongst the citizens in civil matters, as we already have a uniform law for criminal matters, but by applying UCC there will be an equality among citizens in civil matters. It will separate religion from social relations and personal laws, thereby helping the cause of national integration and ensuring harmony in the society. It would also promote gender justice by removing inbuilt discriminatory provisions of personal laws. Additionally, a religion-neutral personal law would uphold freedom of choice, especially in cases of intercaste marriage and interreligious marriage. But with these needs, there come certain challenges, that by upholding a single set of rules, The Uniform Civil Code brought people together, obviously, because people are going to be governed by the same set of rules. But many felt that it infringed their fundamental rights because it went against what was recognized as a component of such right. Right. Now there are two main challenges which have been distributed as constitutional challenges and socio-political challenges. Now coming to the constitutional challenges, the equality right and the freedom of religion are at odds here. The fundamental right to practice one's religion is established in Article 25, like we have discussed. Each religious denomination or section's right to conduct its own business in religious matters is safeguarded in Article 26B, and like we have discussed, Article 29 defines right to preserve distinctive cultures. So equality before law, which is promised in Article 14 and 15, and these rights, so the rights provided under Article 25, Article 26B and Article 29 are not, they're at odds, they're not at the same place. So additionally, I'd like to say that according to Article 25, a person's right to practice their religion is constrained by public order, health and morals. Uniform Civil Code is neither essential nor desirable at this time according to, and like we have seen that the 2018 report of Law Commission, which says that the Uniform Civil Code is neither essential nor desirable at this time. The Commission also contends that secularism and nation's diversity cannot be irreconcilable. Now, next we come on to the socio-political challenges. So, in this particular, we will see that minorities who have distinctive cultures have worried. So, the minority worry that in name of uniformity, the culture of the majority will be imposed upon them, and it will be extremely difficult to bring all these individuals together given the vast cultural variety of India. So, even in a particular religion, there are different sects which follow different rules, which have different cultures, which have different customs. So the adoption of Uniform Civil Code is challenging because the patriarchal outlook of the Indian society also, because they do not want to change that. And this may be observed in the fact that Hindu women only inherit a portion of a land to which they are entitled to, despite Hindu Code Bill has been in place since the middle of 1950s, and even today we can see that after 2005 amendment, still women let go of their right to share in inheritance, or they are not aware about this. So these are the challenges why why people are opposing UCC. Now let's discuss what our judiciary's view exactly is on Uniform Civil Code. So judiciary in three important judgments have there are various judgments regarding UCC, but there are three main judgments that we will be discussing today. So the first one was Muhammad Ahmad versus Shah Banu Begum. So in this particular case, this case was brought before the Indian Supreme Court for the first time in 1985. The court instructed the parliament to draw a uniform civil code in connection with this particular case. Now what happened in this case? Shah Banu's case was for obtaining maintenance money from her husband after she had triple talaq in accordance with the section 125 of the Code of Civil Procedure. So to give you an additional brief about Muslim laws in India, a woman is so in a Muslim marriage there is no concept of maintenance, there is a concept of dower or meher. So here in this particular case what dower was fixed, or what amount of meher was fixed was not enough. So here the Supreme Court intervened, and what the Supreme Court say that a common civil code will help to help the cause of national integration by helping different loyalties to the conflicting ideologies. So here they granted maintenance to Shah Banu Begum in this particular case. The next case that we will be discussing is Sarla Mudgal versus Union of India. So in the Sarla Mudgal case, which raised the issue of bigamy and disagreement over marriage-related issues within the personal laws, was another significant case that gained attention. So what exactly happened in this case was there was a couple, a Hindu couple, and the husband in this particular case changed his religion so that he could get married to some other woman, as bigamy is allowed in Muslim law whereas it is not allowed in Hindu law. So here what did the court say? That when more than 80% of of citizens have been placed under the personal codified law, there is no justification so to keep whatever in the absence even more. The introduction of uniform civil code for all citizens of the territory of India is very necessary. And lastly, the case that we will be discussing is John Valamotum versus Union of India. So in this particular case, the Supreme Court said that it is regrettable that Article 44 of the Constitution has not entered into force. The above provisions, that is the Article 44, is based on the premise that there is no necessary link between religion and the law of persons in a civilized society. A uniform civil code or a common civil code will help the cause of national integration by removing contradiction based on ideologies. So, like we can see, they have asked for suggestions from interested parties to give on their views on uniform civil code. So that's it from that's all from our side for today. Thank you so much for watching. Please like, comment and share if you like this video, and subscribe for more such content. Thank you.